Bharatiya Sakshya Adhiniyam 2023, Part 1. This video and audio is for the rememorization process of section-wise content of BSA. So this will be useful for all lawyers, judges, law students, and the persons who are giving the judiciary examinations. So now we'll see all these sections, total 170 sections are there. Part 4, total part 4 and chapters 12 in this BSA, and one schedule is there. So we'll cover this in two different videos. So in this first part, we'll see chapter 1 to 5 and section 1 to 93. Part first, chapter 1, preliminary. Section 1, short title, application and commencement. 2, definitions. Part 2, chapter 2, relevancy of facts. Section 3, evidence may be given of facts in issue and relevant facts. Closely connected facts. Section 4, relevancy of facts forming part of same transaction. 5, facts which are occasion, cause, or effect of fact in issue or relevant facts. 6, motive, preparation, and previous or subsequent conduct. 7, facts necessary to explain or introduce fact in issue or relevant facts. 8, things said or done by conspirator in reference to common design. 9, when facts not otherwise relevant become relevant. 10, facts trending to enable court to determine amount are relevant in suit for damages. 11, facts relevant when right or custom is in question. 12, facts showing existence of state of mind or of body or bodily feelings. 13, facts bearing on question whether act was accidental or intentional. Section 14, existence of course of a business when relevant. Admissions. Section 15, admission defied. 16, admission by party to proceedings or his agent. 17, admissions by person whose position must be proved as against party to suit. Section 18, admission by person expressly referred to by party to suit. 19, proof of admissions against person making them and by or on their behalf. 20, when oral admission as to content of document are relevant. 21, admissions in civil cases when relevant. 21, admissions in civil cases when relevant. 22, confession caused by inducement, threat, coercion, or promise when irrelevant in criminal proceedings. 23, confession to police officer. 24, consideration of proved confession affecting person making it and others jointly under trial for same offense. 25, admissions not conclusive proof but may stop. Statement by persons who cannot be called as witness. Section 26, cases in which statement of relevant fact by person who is dead or cannot be found, etc. is relevant. 27, relevancy of certain evidence for proving in subsequent proceedings truth of fact therein stated. Statement made under special circumstances. Section 28, entries in books of account when relevant. 29, relevancy of entry in public record or an electronic record made in performance of duty. 30, relevancy of statement in map, charts, and plans. 31, relevancy of statement as to fact of public nature contained in certain acts or notifications. 32, relevancy of statement as to any law contained in law books, including electronic or digital form. How much of a statement is to be proved? Section 33, what evidence to be given when statement forms part of a conversation, document, electronic record, books of series of letters or papers. Judgment of court when relevant. Section 34, previous judgments relevant to bar a second suit or trial. 35, relevancy of certain judgments in probate, etc. jurisdiction. Section 36, relevancy and effect of judgment, orders, decree, other than those mentioned in Section 35. Section 37, judgments, etc., other than those mentioned in Section 34, 35, and 36 when relevant. Section 38, fraud or collusion in obtaining judgment or incompetency of court may be proved. Options of third person when relevant. Opinion of third person when relevant. Section 39, opinions of experts. 40, fact bearing upon opinion of experts. 41, opinion as to handwriting and signature when relevant. 42, opinion as to existence of general custom or right when relevant. 43, opinion as to usage, tenant, etc. when relevant. 44, opinion on relationship when relevant. 45, grounds of opinion when relevant. Character when relevant. Section 46, in civil cases, character to prove conduct imputed irrelevant. 47, in criminal cases, previous good character relevant. In Section 48, evidence of character or previous sexual experience not relevant in certain cases. 49, previous bad character not relevant except in reply. 50, character has affected damages. Now part 3 on proof. Chapter 3, facts which need not be proved. Section 51, fact judicially noticeable need not be proved. 52, facts of which court shall take judicial notice. 53, facts admitted need not be proved. Chapter 6 of oral evidence. Section 54, proof of facts by oral evidence. Section 55, oral evidence to be direct. Oral evidence to be direct. Chapter 5 of documentary evidence. Section 56, proof of content of documents. Section 57, primary evidence. Section 58, secondary evidence. Section 59, proof of document by primary evidence. 60, cases in which secondary evidence related to document may be given. 61, electronic or digital record. 62, special provisions as to evidence related to electronic record. 63, admissibility of electronic records. 64, rules as to notice to produce. 65, proof of signature and handwriting of a person alleged to have signed or written document produced. 66, proof as to electronic signature. 67, proof of execution of document required by law to be attested. 68, proof where no attesting witness found. 69, admissions of execution by party to attested document. Section 70, proof when attesting witnesses denies execution. 71, proof of document not required by law to be attested. 72, comparison of signature, writing or seal when author admitted or proved. 73, proof as to verification of digital signature. Public documents. Section 74, public and private documents. 75, certified copies of public document. 76, proof of document by production of certified copies. 77, proof of other official documents. Presumption as to documents. Section 78, presumption as to genuineness of certified copies. 79, presumption as to document produced as a record of evidence, etc. 80, presumption as to gazettes, newspaper, and other documents. 81, presumption as to gazettes in electronic or digital record. 82, presumption as to maps or plans made by authority of government. 83, presumption as to collection of law and report of decisions. Section 84, presumption as to power of attorney. 85, presumption as to electronic agreement. 86, presumption as to electronic record and electronic signatures. 87, presumption as to electronic signature certificate. 88, presumption as to certified copy of foreign judicial records. 89, presumption as to books, maps, and charts. 90, presumption as to electronic messages. 91, presumption as to due execution, etc. of document not produced. 92, presumption as to document 30 years old. And 93, presumption as to electronic record 5 years old. So friends, this is a part 1. This BSA, that is New Evidence Act, Bharatiya Sakshya Adhiniyam, is very important in trial court. It is equally important in appellate court also. But a lawyer who want to become a famous should lead excellent cases in trial court. Through trial court, there is a way to be famous at your state level and later at national level also. So Evidence Act is very important. These 5 laws, specific procedural laws, that is all these important, that is a BNS, BNSS, BSA, Limitation Act, and Evidence Act. These are 5. And if you are practicing apex court, and high courts, then Constitution of India is also there. So this 6 law, unless and until you are established lawyer, at least once in a 3 month, you should revise all these 5 laws. Okay, and later that, section-wise content, just hear these videos, audios, while you are traveling, while you are doing your exercises, while you are doing your home type work, like that. If you are interested in kitchen, if you are interested in cleaning, that time you can play and you can try to remember section-wise content. So this is the part 1, friends, and part 2. In part 2, we will complete this BSA. Thank you very much. Jai.